5 seconds to go. Start. That the court would not enter into credibility of the evidence with a view to substitute its own opinion for that of the High Court. That the court would interfere where the High Court has arrived at a finding of fact in disregard of a judicial process, principles of natural justice, or a fair hearing, or has acted in violation of a mandatory provision of law or procedure resulting in serious prejudice or injustice to the accused. This court might also interfere where, on the proved facts, wrong inferences of law have been drawn, or where the conclusions of the High Court are manifestly perverse and based on no evidence. The scope and width of appeals under Article 136 has been elaborately articulated by a three-judge bench of this court in Pappu versus State of Uttar Pradesh. This judgment, authored by one of us, after noticing catena of judgments on the issue, the three-judge bench summarized the principles as under. In summation of what has been noticed herein above, it is but clear that as against any judgment, final order, or sentence in a criminal proceeding of the High Court, regular appeals to this court are envisaged in relation to the eventualities specified in Article 134 of the Constitution of India and Section 2 of the Act of 1970. The present one is not a matter covered thereunder, and the present appeals are by special leave in terms of Article 136 of the Constitution of India. In such an appeal by special leave, where the trial court and the High Court have concurrently returned the findings of fact after appreciation of evidence, each and every finding of fact cannot be contested, nor such an appeal could be dealt with as if another forum for reappreciation of evidence. Of course, if the assessment by the trial court and the High Court could be said to be vitiated by any error of law or procedure, or misreading of evidence, or in disregard to the norms of judicial process leading to serious prejudice or injustice, this court may, and in appropriate cases would, interfere in order to prevent grave or serious miscarriage of justice, but such a course is adopted only in rare and exceptional cases of manifest illegality. Tersely put, it is not a matter of regular appeal. This court would not interfere with the concurrent findings of fact based on pure appreciation of evidence, nor it is the scope of these appeals that this court would enter into reappreciation of evidence so as to take a view different than that taken by the trial court and approved by the High Court. Coming to the facts of present case at hand, the deceased was an agriculturist, and on 14th March 2006, during a quarrel between PW1 and the appellant, PW1 gave a beating to the appellant with a stick. Thereupon, the appellant gave a report against PW1 in Amravati police station, and the same was registered as crime number 35 of 2006 for the offence punishable under section 324 and 506 of IPC. After completion of investigation, the police filed charge sheet against PW1 and the same is pending. In that connection, the appellant demanded money from PW1 for treatment of his knee, to which both the deceased as well as PW1 agreed for payment, but on a later date, the deceased as well as PW1 refused to pay the appellant. Stop.